excuse me for that intervention. I hope no one minds if the meeting's being recorded. If you want to also, if you don't want to be seen on the screen, you can mute your screen. So it's being sponsored by FirstFollowers and by the Champaign County Bailout Coalition. So I'm going to hand over to Briana, who will just talk a little bit about the Champaign County Bailout Coalition before we allow Briana Payton to share her experience and wisdom with us about the Pretrial Fairness Act. So Briana, do you want to tell us a little bit about the Bailout Coalition?
Oh my goodness. Hi, I'm sorry. I had a little mishap there. I'm Briana. I'm part of the Champaign County Bailout Coalition. I've been a member since I think about 2019, late 2019, early 2020. We've existed since 2017. And since then, we've paid over, I'm pretty sure it's over $200,000 towards bailing folks out so they can get the be with their families, get the representation that they need, and just be out of the jail here. So what we do is specific to our county. So yeah, and that's all about CCPC. We are so excited to not have to exist anymore. Yeah, so thank you, James.
All right, fantastic. Thanks, Briana, and thanks to the Bailout Coalition for all the work you've been doing to get people out of jail when they wanted to charge these horrific fees for people just to buy their freedom. So that's not going to happen anymore, and we want to make sure that the people in Champaign County in particular are going to follow the Pretrial Fairness Act. So I want to just introduce Briana Payton. I've worked with Briana for several years. She's a fantastic activist, policy analyst. She's worked for years and years at all levels in terms of bringing the Pretrial Fairness Act into play. She's worked at the grassroots level. She's worked with the state legislators. She's worked with policy analysts and so forth. She started doing this work with the Chicago Community Bond Fund. She's now a policy analyst at Chicago Appleseed. And I could tell you a lot more about how wonderful Briana is and how she can fire up a crowd when she's in front of a rally. But here she's going to present that other side of her, which is the expert. And we are very honored to have her here to make this presentation for us. So thanks so much, Briana. We look forward to your presentation. She will speak for maybe 35, 40 minutes, and then we can take questions, or if people want to drop things in the chat, we can take them then. Thank you very much. Briana, I'll take it away.
Thank you so much, James, for having me. And we know that you have also an amazing track record in this work, and we could sing your praises for days. And so super excited to be here with you and grateful for the work that you've led on many different levels too. Hi, everybody. As James said, my name is Briana Payton. I am newly the Associate Director of Policy and Advocacy at Chicago Appleseed, the Center for Fair Courts, which is a proud member of the Coalition to End Money Bond and the Illinois Network for Pretrial Justice. We have been working on the Pretrial Fairness Act at a statewide level since 2019 and at a county level since 2016. I've been blessed to be on the team since 2020 and have learned a lot during this time. So I'm glad to be able to share with you. But I would love to get a quick pulse check in the room on how many people are familiar with some of the problems with the money bond system by a show of hands. We got a couple people that are familiar. I see a thumbs up. How many people are familiar with the Pretrial Fairness Act by a show of hands or a thumbs up? Okay, awesome. So some of this then may be review for some of you, but allow me to go back over the basics for anyone who this may be new information for them. And then I'll be happy to take any, further questions once we wrap up. Sound good? Okay, cool. So I'll pull up my PowerPoint. Can everyone see it? Okay, great. So we're going to talk about pursuing pretrial freedom in Illinois. And just a quick overview of what this presentation is going to cover, who we are at the Illinois Network for Pretrial Justice, what are the impacts of money bond and pretrial incarceration, how that system works, and then how the Pretrial Fairness Act works and the changes that it makes to the system, how it makes our community safer, and what our concerns are as we move into implementation and how you can support. And so without further ado, we've got a lot to cover, so we can jump in. As I mentioned, the Illinois Network for Pretrial Justice is a network of statewide organizations with folks from all corners of the state, from Waukegan to Rockford to Chicago to East St. Louis, Metro East, just different parts of the state, with all types of organizations, policy organizations, community-based justice organizations, bail funds, faith-based organizations, legal organizations, just all types of folks, including as well folks who are organizing with community members and directly impacted people. And we've all come together under this shared goal to advocate for pretrial fairness, to advocate for pretrial justice, which looks like bond reform, and also advocating around a few different related issues that we'll talk about. And again, that started in 2019 in January, but before that, this work started in Cook County with folks organizing as a part of the Coalition to End Money Bond in 2016. And that group was able to collaborate with some civil rights attorneys to file a lawsuit and do some advocacy that resulted in bond reform happening locally in Cook County through a general order from our county's chief judge that decreased the use of money bond and decreased the number of people in the jail by about 2,000 people on a given day, 10,000 people in a given year. But that was only partially being followed, and it was only benefiting folks in Cook County, which is why it was so important to reach out and connect with folks who were doing this work across the state and build a statewide movement for pretrial fairness. And it's that movement that birthed the Pretrial Fairness Act that is now the law of the land here in Illinois. So why are we doing this work? What is the problem and kind of the statistics around money bond in Illinois? So in Illinois, there are 92 jails across our 102 counties. We have an excessive number of counties in this state, and more than 250,000 people spend time incarcerated in jails in Illinois every year. More than 90% of them are incarcerated pretrial. And though the Pretrial Fairness Act has now taken effect, it is still the case that most of the people who are there are incarcerated only because they cannot afford to pay a money bond. We're in the process of changing that, but right now, that is still the reason why a large majority of these thousands of people are in jails across our state. And so the money bond system, it creates a two-tiered system of the presumption of innocence only being available to those who can afford it. And so just to kind of give you a sense of how that system works, when someone is arrested, charged and booked into the custody of law enforcement, they go before a judge for what's called a bond hearing. And at the bond hearing, the judge has a few different options. They can issue an I bond if they determine that it is safe to release someone on their own recognizance, meaning that that person is agreeing to come back to court and to avoid any future potential offenses. The judge can deny someone bond if they determine that person, that they do not believe that it's safe to release that person due to a potential safety threat to another person, or a risk that the person would not come back to court purposely, that they would flee prosecution. And then you have this middle ground with money bonds where they can say, the person can be released if and only if they pay X amount of money. And so that is where you end up with one decision from a judge, but two different outcomes depending on who is standing before the judge. If the person standing before the judge can access that amount of money or has that amount of money on hand, they get released. If the person does not have access to that amount of money, they are incarcerated. Some people justify this system because of the idea that it is a sort of, it gives you skin in the game. It's the idea that, it'll give you motivation to come back to court, because the idea is that you will not get your money back unless you come back for your court dates. That is how it's supposed to work. But let me tell you, that is not how it actually works for a few reasons. So for one, it doesn't work that way for one, because a lot of people who are not able to pay the money bond to get out to begin with. So it is not serving a purpose of bringing people back to court, because they're not able to pay it to get out in the first place. For two, people don't often get their money back at the end of their cases, regardless of whether they come back to court. In a study that was done by the Civic Federation over the past 5 years, only 20% of the money that was paid out in money bonds was actually returned to families. And so this idea that people are motivated by getting their money back. If they were, they're not getting the money back anyway. And so that's not really making sense either. And lastly, the data just doesn't show that money bonds actually improve court appearance rates. Instead, even in situations like with bail funds, like from what Miana spoke about and what we saw at the Chicago Community Bond Fund, is even when we put up the money for other people and they didn't put up any money, they had better court appearance rates because they had some support. We had people on our team that would call and remind them of their court dates. The data shows that what helps people come back to court by and large is court reminders and other assistance such as transportation or childcare, because those are the types of things that actually keep people from going to court a lot of the times. So money bond doesn't serve the purpose that it claims to serve, and it creates a two-tiered system of justice where people have different experiences in the system depending on how much money they have. And it also denies people their due process and their constitutional rights, because judges are using something that's supposed to be a condition of release to jail people. But if the judge wants to jail someone and to deny them bond, there is already a legal process in place to go through that. But what judges were doing is they were shortcutting that legal process by setting a money bond. When they set a money bond, they didn't have to provide the same reasoning or justification on the court record and in court as they would have had to in order to deny bond. And so because it's technically releasing someone as long as they pay the money. And so it's a shortcut that allows judges to deny people due process that they are supposed to be entitled to under the law. And so as you could imagine, it needed to be abolished. It needed to be abolished, not just because it was an unjust system or because it was unfair or because it was creating, different outcomes for people that were rich versus poor, but it also was doing irreparable harm to people's lives who were legally presumed innocent. And so I'm going to talk a little bit about some of the harms of pretrial incarceration. And there are many, so this will not be exhaustive, but just to name a few. When someone is incarcerated pretrial, they are immediately at risk of losing their job. I'm sure that many of us know that not all jobs have a great policy when it comes to no-call, no-shows. So even being kept overnight in a jail or for a couple of days can cause someone to miss work and become a no-call, no-show for their job and be fired on the spot, let alone the fact that people are often not just kept in jail for a night, but they might be kept in jail for a few days as they're going to court, or they might be kept in jail for weeks or months if they are ordered or if they're given an unaffordable money bond. And then they're even more likely to lose their job because of how long they're becoming not useful to their employer. And so you have people that are losing their jobs because of wealth-based pretrial incarceration. And then when people lose their jobs, you start being unable to pay your bill. And what is the biggest bill that all of us are dealing with on a daily basis? Rent, housing. So people lose their jobs. And then what immediately often follows is people losing their housing. We've seen, families with small children get evicted because the person who was providing for that family was locked up on an unaffordable money bond. And so people lose their housing. And then when you lose your housing and you're not able to take care of your kids, we have had people that have permanently lost custody of their very children, not because of a conviction or a prison sentence, but because of being in jail pre-trial and not being able to suddenly, without notice, arrange for somebody to be able to take in their kids for an undetermined amount of time. And so you have people losing custody of their children. Furthermore, those are some of the things that kind of fall apart in people's lives outside of jail when they're inside, let alone what people are experiencing when they're in jail. Jail is an incredibly deadly and dangerous place where people are constantly facing risk of violence from those around them, including guards and officers. And so it can be really detrimental not only to people's physical safety, but their mental health, because you're in this place. You don't know how long you're going to be there. You don't know if or when you're going to be able to get out. You don't know if your family's going to be able to come with the money. Your family might be making difficult decisions about whether to put food on the table or let bills go into, being past due in order to get you out. And so people's mental health often deteriorates in jail. People went into jail with mental health issues, which some people argue that folks with mental health issues should be in jail, but that ignores the fact that jail often worsens mental health issues. And then you've had people that go in without mental health issues, but because of the conditions that they're in, they develop those issues. For example, the suicide rate in jails is 3 times that of the general population. It's even worse than in prison. And I've talked to people who have spent time in jail and prison, and some people will tell you that jail is worse because of all the uncertainty. You don't have an out date. You don't know what's going to happen. It's a much more transient population. It's hard to make community. Like, there's so many things that can make it just very difficult to survive, let alone have mental soundness while you're in a jail. So those are some of the things that people suffer while they're there. And the risk of committing suicide in a jail is that it is most likely to happen within the first week. So it doesn't take a long time in a place like that for things to really, really unravel and go downhill for someone. And then additionally, being in jail pre-trial messes up people's case outcomes. So in particular, it creates more convictions because you have to think about it. When you're in jail, it's harder for you to participate in your own legal defense. It's harder for you to talk to your lawyer, have a private conversation. It's harder for you to go gather evidence that might prove your innocence or to contact witnesses. You're having to talk to somebody else to do all of these things for you while you're stuck in a cage. So because of those different things, and then you're also showing up to court in a jumpsuit and in handcuffs, which might just even affect how the judge views you from a bias standpoint and how they, rule on your case. And so people that are incarcerated pretrial have a 4 times greater likelihood of being sentenced to jail, which is a sentence of a year or less, a 3 times greater likelihood of being sentenced to prison, 3 times longer jail sentences, twice as long prison sentences. And these are with people that are similarly situated to somebody else. So this means like you have similar charge, similar background. The only difference is you are incarcerated pretrial. These are the things that you will likely see different in your outcome from somebody in your same situation who was released pretrial or who was able to buy their way out pretrial. And then the biggest thing about the people should know about pretrial incarceration is that it doesn't just make things worse for the person, but it does the opposite of keeping us safe, because pretrial incarceration, because of the way that it causes people's lives to spiral and to become less stable, it actually increases the likelihood that somebody will have future contact with the legal system. It increases the likelihood of future charges because you're losing the things that help people to build successful law-abiding lives, things like housing, things like employment, things like connections to loved ones. And so the whole system is putting people in a worse position than before, which ultimately puts our communities in a worse position. And so, oh no, it doesn't want to play the video. I might come back to this, but what you just heard is pretty much a summary of how these things affect people. This was just a video where you would have heard for a few minutes from people who are directly impacted, and I can try to pull it up, but I just want to be able to keep moving through the presentation so that we can have time for questions. So I'm going to skip past this and circle back afterwards to see what's up with this link, because it normally always works. So we've talked about the problems with the money bond system and with wealth-based pretrial incarceration and with pretrial incarceration in general. And so now we're going to walk through the Pretrial Fairness Act using the lens of these principles. There are principles that the Coalition to End Money Bond came up with to kind of guide our vision for what we were fighting for when it comes to pretrial justice. You don't just want to say that we want to end money bond. For us, ending money bond is a target, but reducing pretrial incarceration is the ultimate goal, because the harm comes from pretrial incarceration, and money bond was something that was used to have way too many people, going through pretrial incarceration. And so we had principles to kind of really make our goals clear. And so I'm going to walk through what those principles are and then show how the law achieves what those principles were aiming for. So there's 6 of them. The first principle is that money should never be a determining factor in whether somebody is free or not while they are awaiting trial. And the way that the law kind of fulfills this principle is it completely abolishes the use of money bond. There are other states where they took away money bond, but only for lower level charges, or some states where they took away, like New York, for example. In New Jersey, they took away money bond, but they still use it in a small minority of cases. We are of the belief that there is no situation where money should be the thing determining whether somebody is in jail, which is why we went to the length of just completely abolishing it. And so now when people are going to court, that is just not an option that judges have on the table. The second principle is that release should be the norm and detention should be the carefully limited exception. And this is not just something that our coalition came up with. This is already the law. This is already cited in Supreme Court cases about this issue of pretrial incarceration. because we are supposed to be innocent until proven guilty in this country, it is really supposed to be the exception, not the rule, that you are punishing and caging people before they have been convicted of anything. And we know that that's important because there is a such thing as people being wrongfully accused, wrongfully convicted. We know that police do not always tell the truth. Complaining witnesses might be falsely accusing someone. And even if somebody is alleged to have done something, they have to have the right to go through a trial and present their case for their innocence. And so the way that we wanted to achieve this was we wanted to make sure that not every charge was eligible for pretrial incarceration. That's important because if you take away money bond and you only allow the options to be someone is in or they're out, but you give complete free reign on that everything can be lead to incarceration, then you would see the same over-reliance on pretrial incarceration that you saw under the money bond system. It would just be done without money. And if we ended money bond but did not put a dent in the issue of how many people are actually being caged pretrial in our state, then we would not have actually advanced justice. And so the law creates a detention eligibility net so that there's only the most serious charges where there's a safety concern or a concern about someone fleeing prosecution is eligible to be considered for pretrial incarceration. The other charges have to be released, and the judge can set conditions of release, such as checking in with the pretrial services officer, possibly being electronic monitored, even though we have major problems with that as well. But the judge can set those other conditions. But in those cases, as long as the person is not already out on a case, then in those lower level charges, the person is not eligible for pretrial incarceration. And so we've already seen people who have been released since the law has gone into effect because they were simply charged with something that was not detainable, which is a beautiful thing. And we look forward to seeing more of that. Another way that the Pretrial Fairness Act makes it so that release is the norm is it creates what's called cite and release procedures, which is that police will be required to release people who are accused of very minor things, ordinance violations, petty offenses, think loitering, thinking, public, disorderly conduct or something like that. Things that are class B and C misdemeanors and ordinance violations and petty offenses, as long as there's not an active safety threat to that person or the people around them, then law enforcement is required to give a ticket or a court date and then send the person on their way. And then for people that are charged with something that is detention eligible, the Pretrial Fairness Act does not throw people in that situation under the bus because it does raise the standard that's required to impose pretrial incarceration. It raises the standards of evidence and the standards of justification that are required. Under the money bond system, not much justification was required at all, but under the Pretrial Fairness Act, there are 3 things that must be met before pretrial incarceration can be imposed. There must be probable cause that a person committed a detention eligible offense. There must be a real and present threat to the safety of a person or the community, or a high risk of willful flight. And a high risk of willful flight is a change from the previous system where people could be jailed off of a likelihood of just missing court. But we changed it to a high risk of willful flight because people should not be jailed because they've missed court in the past if it is not showing a risk that they will purposefully flee prosecution. Court cases can have so many different court appearances over the course of a full case. A felony case, for example, can last 1 to 2 years, and you might have a court date every month, and people might have difficulty getting childcare, getting time off work. They might have been miscommunicated with by the court about when their court date was, or they might have forgotten. And so there's all sorts of reasons why people might have missed court, but they were not actually fleeing from prosecution. And so the Pretrial Fairness Act makes sure that people are not being jailed just because they've missed court before, but that the judge is actually having to assess for a risk of fleeing prosecution. So once the qualifying offense is identified and those risks of safety or flight are identified, then the third standard is that there are no conditions other than pretrial jailing that will protect the public from those threats of safety or flight. So if there is any less restrictive condition, whether that be pretrial service check-ins or electronic monitoring or anything else that could be imposed instead of jail, the judge is required to do that instead of pretrial jailing. And they have to rule by clear and convincing evidence that nothing else would be sufficient before they can order someone to pretrial incarceration. And it is an appealable decision. It's an appealable decision. So that's important to remember as well. So just for those who are visual learners, to kind of show you what it would look like somebody going through the system under the Pretrial Fairness Act. If somebody is stopped by police, if they're charged with, if they're accused of something that is very low level, then they have that off ramp of being cited and released, given a ticket or a court date and told when to come back. If they're not cited and released and they're arrested and booked into police custody, there is the opportunity for law enforcement, the discretionary release, which is being released from the police station after you've been booked or processed, fingerprinted, et cetera, without having to go to court. There's another set of charges that is eligible for. But if you're not booked and released from law enforcement custody and after you're given your court date, then you go to a first appearance hearing, also known as a conditions hearing. At the first appearance hearing, people who are charged with charges that are not detention eligible will be released with conditions that are set by the judge. If someone is charged with something that is detention eligible, it depends on whether the prosecutor asks for pretrial detention. If the prosecutor doesn't ask for detention, then that person will also be given release and with conditions that are set by the judge. But if the prosecutor does ask for detention, then the case will proceed to a detention hearing. The detention hearing might happen immediately after the initial appearance, or it might be pushed back 24 to 48 hours, depending on whether the prosecution or the defense attorney asks for more time. But it will happen within 24 to 48 hours. And then at the detention hearing, both sides, prosecution and the defense, to present their arguments about why somebody should be detained or released. And the judge reviews the evidence, reviews the arguments, listens to any witnesses that are called. And so this is a much more robust hearing than what you get in the bond system. The fact that there's even 2 hearings is already making it more robust, because under the previous system, you might have a singular 2 to 5 minute hearing where the decision is made and the amount of money is set, and that's the end of it. So now you have a 2-part hearing process. And at the detention hearing, it's longer. We're already seeing they're taking more like 15 to 20 minutes. And then the judge listens to what's presented and makes a decision to either release the person with conditions, or if they do find the person poses a risk to another person and or the community, or a high risk of willful flight that can't be addressed by anything other than pretrial jailing, that is when pretrial detention will be ordered. So that's how the Pretrial Fairness Act works. I will briefly go through the last three principles, but that is like the bread and butter of how the Pretrial Fairness Act works. But it is a nearly 400 page bill, so it does a lot of things. So I'll touch on some of the other reforms that it also includes. The 4th principle is that courts should help accused people attend court hearings and restrain their freedom as little as possible when they're innocent and awaiting trial. One of the ways that they do this is they reform the warrant process. Under the previous system, if somebody missed court, a judge would immediately have to issue a warrant for their arrest. Under the new system, if someone misses court, a judge has an option to issue a notice to appear in court, which gives the person an opportunity to voluntarily come back to court within 48 hours to show that they're not purposefully fleeing, and so that they don't have to be penalized for missing court. Say it was an accident or something of that nature. Sorry, did somebody say something? Okay, just making sure. And then that is optional. So, judges will have a choice of whether they want to issue a warrant or not. But we hope they will use the new optional thing, because it's a lot less scary. When people find out there's a warrant for their arrest because they missed court, it might actually make them less likely to come back, because they don't know if that means that as soon as they turn themselves in, they're going to jail or what have you. So this is to create a more peaceful process for coming to court if you were never trying to run from prosecution in the first place. And then the Pretrial Fairness Act also reforms electronic monitoring. Okay, I thought that I had the EM reforms listed here, but I'll go back and just say them okay, here it is, electronic monitoring. So the reforms to electronic monitoring are as follows. There are 4 of them. Judges must reconsider orders to electronic monitoring every 60 days. Unfortunately, these reforms have been in effect since January 2022. Unfortunately, we haven't seen this make a huge difference just yet, because when judges reconsider, they have a right to just basically do the same thing they already did, which is leave someone on EM. But we were trying to make it so that judges would consider letting people off of electronic monitoring if somebody was complying with the rules and showed, potential to be able to comply while released off of it. But we were hoping to see more effects of that, but so far, not so much. But that was the intent of it. Number 2, accused people must be given movement to do essential tasks. The Pretrial Fairness Act guarantees at least twice a week, people have to be let out of their homes to go do things to take care of themselves. Right now, the sheriff, before this was in effect, the sheriff in Cook County had a system where people were regularly not being given permission, even when they requested it and submitted the paperwork. They were not being given permission to do things like go to the grocery store, go to the doctor, things of that nature. And so now people can get that movement to go and do those things they need to do. The Pretrial Fairness Act also requires higher standards for if someone is going to be charged with felony escape from electronic monitoring. Previously, people were charged with that, even just for minor violations of electronic monitoring. And now there has to actually show intent to actually run away and escape from electronic monitoring before that charge can be filed. So we have seen escape charges against people drop significantly. And lastly, because electronic monitoring is a form of incarceration, people under the Pretrial Fairness Act must be given credit towards their sentence for any time spent on electronic monitoring while awaiting trial. So the next principle is that courts should only use restrictive pretrial conditions to ensure court appearance for people who have been proven to be willfully avoiding prosecution. Again, so this is about reforming the way that violations of pretrial conditions are handled. So if somebody has a minor violation in the past, they would just be taken to jail sometimes for the rest of their case. But under the Pretrial Fairness Act, somebody can only be sent to jail for the rest of their case if they're charged with a serious misdemeanor or a felony. If it's a minor violation, there are other sanctions available. The judge can give them a written admonishment, give them a verbal admonishment, even sentence them to 30 days in jail, but they no longer can send people to jail for the rest of their case for anything lower than a Class A misdemeanor. And so that's really important because, you know, people were getting put in jail for the rest of their case because of like minor EM violations, electronic monitoring violations. And then I missed over this one. Accused people should be viewed holistically, and risk assessment shouldn't be used as substitutes for individualized decision-making. So the law limits the role of risk assessment tools and makes it so that they cannot be the sole basis for any pretrial decision about whether someone is released or not. And it allows attorneys to challenge risk assessment criteria in court. And it also, like I mentioned before, it prohibits people from being deemed a high risk of fleeing just because they've missed court in the past. They have to find a new standard to actually assess for the risk of fleeing on purpose, not just missing court on accident. So lastly, the last principle is that pretrial practices should be transparent and accountable. So it requires robust statewide data collection so that we can see how the system is working and where accountability is needed to make sure that people's rights are being protected. So I'm about to pretty much wrap up. I will just say briefly, this makes our community safer because we are safer when finances do not determine freedom and that the facts of each individual case are considered. And this will reduce incarceration, and reducing incarceration does strengthen our communities, even though many people believe that incarcerating people is what keeps us safer. What people don't often recognize is that incarceration spits people out in a worse condition than they went in. And so it just causes cycles of harm and violence and trauma in our communities. Because it does nothing to rehabilitate, it does nothing to actually address the root causes of the different things that are happening. And just the data shows that reducing and eliminating money bond has not caused any rise in crime and missed court dates in any of the jurisdictions that have put it in practice. In Cook County and specifically, when we doubled the number of people released pre-trial without paying money, over 99% of them successfully and safely return to their communities. And even the people that are deemed high risk on risk assessment tools, almost 99% of them were not arrested for having a new violent offense while awaiting trial. So what we're up against is misinformation, for one. We know that there was misinformation happening before the law went into effect. There were fake newspapers sent out all across the state, and we fully expect there to be more misinformation now that the law is going into effect, because what people are going to try to do is take isolated incidents and blame it on this reform and say, you know, we would have been safer if this didn't happen. But what people have to remember, and what I encourage everybody here to remember, is that these isolated incidents were already happening under the money bond system, for one. The money bond system was never keeping us safe because it was always based on money. And two, no system is going to be perfect. So we can't compare the new system to the standard of perfection. We have to compare it to, is it more fair and is it more just than the system we had in place? And this is going to be much more fair and much more just than the system that we had in place before. And additionally, they're going to be trying to capitalize off of what happens in like 1% of cases to say what we should do in the 99% of cases. And we cannot make public policy that way. So when you see isolated incidents, we do not, minimize the weight of those things that happen in different tragedies in our community. But in the same way that if a tragedy happened on a street that you live on, because one person did it, you wouldn't want them to come down and lock down everybody on your block, is the same way that we can't treat everybody that has a case pending according to what happens in 1% of cases. We're concerned about risk assessment tools. There is a statewide risk assessment tool being developed. And from what we've seen, risk assessment tools often perpetuate racist outcomes because sometimes they take into account things like, well, do you have stable housing, or do you have a job, or do you have XYZ issues to determine how risky it is to release you? But that ends up discriminating against Black people because of Black people are discriminated against in the job market, in the housing market, and all these different things. And so some of the standards and even the criminal legal system were discriminated against. So when they're assessing risk, because have you ever had an arrest? Well, Black people are more likely to be racially profiled and all these different things. So we have problems with these tools, but we couldn't outlaw them. So there is one being created for the state and they're already in use. And so we're monitoring that process to see what happens. And then we are definitely concerned with false alternatives to incarceration, namely electronic monitoring expanding in the absence of money bond. We do not want judges to, every time they want to release somebody, just to cover their tails now, to try to put them on electronic monitoring when the data shows that electronic monitoring doesn't keep us safe. It doesn't improve outcomes for making it to court or, having no new arrests, but it also ruins people's lives because it makes it impossible for them to just do the things they need to do to take care of themselves. So we're raising our voices, we're sounding the alarm in partnership with folks like James to make sure that folks know that in the absence of money bond should not mean another form of incarceration. It should mean more pretrial freedom. So what you can do to help, you can raise awareness of pretrial incarceration in your networks. If you want to bring us in for a teach-in like this to a community or a group you're a part of, don't hesitate to reach out, and also follow us on social media. We are at End Money Bond on Twitter, on Instagram, and on Facebook. And if you want to bring us in for a teach-in, you can contact us at info@endmoneybond.org. So there you have it, folks. There's a lot of information and I can take any questions.
Thank you so much, Briana, for that. I'm going to ask everyone on the call to take a deep breath. You've given us a lot of information, so let's just ingest it a little bit and get ourselves, relaxed and ready to engage if we can. If people have questions or comments, I see one question in the chat already. I've got a few, and there might be people in the room here that want to ask some questions. But let's give the first. Let's get the first question that's in the chat. Where'd it go here?
I see the question of who benefits from electronic monitoring.
Electronic monitoring, yeah.
People who want to see Black and poor people under state surveillance and control seem to have a large stake in electronic monitoring. The system that wants to, as many people locked up as possible, the system that wants to perpetuate the idea that incarceration is our key to safety, benefit from electronic monitoring. And I think what people get from electronic monitoring is a mental sense of safety. So it's not that the data shows it keeps us safe, but they believe that if somebody's on electronic monitoring, it keeps them safer. And so there's kind of a mental soothing that's happening there, but it's not actually based in data or reality. And so that's one thing that is the case. And statistically, the only cases where the data has shown any sort of benefit might be situations where there is a very specific victim and a very specific place that someone is supposed to avoid. But like the type of house arrest that locks people down and keeps them unable to kind of do the basic things they need to take care of themselves benefits no one. Jocelyn.
Could I add something there?
Yeah.
Okay, I've been studying electronic monitoring for a while, and I think one of the things, so the State Office of Pretrial Services has put electronic monitoring into place in 70 counties, and there's a contract with one company, Track Group. So who benefits from that? The companies also benefit from that as well. There's money to be made, so that's another reason to oppose it. I see Jocelyn has a hand.
Yes,
Um,
That was really, and it was answered in the chat. I wanted to know how much it costs and is there a private company that's benefiting? So those things were, and thank you for answering that.
yeah, under the Pretrial Fairness Act, though, there is supposed to be no more people paying for electronic monitoring. Now that it's going to be handled by the statewide Office of Pretrial Services, it is supposed to be offered at no cost.
Yeah. At the moment, on the Champaign County website, it still gives you costs, and it's been true all the way through. I understand it's not always true everywhere, but I will be interested to see if that has changed, because actually that was not challenged in court.
What
right?
was
I'm sorry. The thing that was challenged first in court was bail, and not electronic, and not the other provisions. So the fact that we apparently still have people being charged sounds like there's something wrong there here in Champaign County.
Yeah, I'm going to look into it. It might have to do with which counties are being overseen by the Office of Statewide Pretrial Services, because that's the office that's providing electronic monitoring at no cost to the counties or to the people that are accused. So if it's the case that Champaign County is not one of the 71 counties that's being kind of taken over by the Office of Statewide Pretrial Services, that might be why we're still seeing charges. But I do believe that the plan is for the Office of Statewide Pretrial Services to take over in all the counties sooner or later, but they're phasing it in and starting with counties that didn't already have their own system set up.
I think they are here.
They are.
Okay.
But then
Thank you.
that's changing. That should be changing very soon then.
Okay, good.
We've actually already experienced someone who's paying fees, having the fees taken away. So that's been done. And I think the local public defender has played a big role in pushing for that and making sure it's implemented. I have a question from Kayla.
Yes.
Kayla?
No, you said it correct.
Okay.
So my question is, Briana, I know you were speaking earlier about like bond and how like when you pay, you get it back. So actually that was very new information for me. I never knew that. I thought that once you paid the bond, like the state or whoever else keeps the money. So what is the process for that, and how does that work? And how do you go about, like, if you did pay your bond, how do you go back if you had to get it back? Because I know some people pay their bond like collateral on their house or take out a loan or something like that. So how does that work?
The problem is, so that's the problem, Kayla. The reason you don't know that is because most people don't get it back. You're supposed to, but a lot of times the court will eat it up with fines and fees. A small percentage might go to restitution. And so that's why, and only in the last 5 years in Illinois, it's only gone back to people in like 20% of cases. And so unfortunately, I don't have very specific advice on how to go about getting it back if someone didn't. They might just have to go visit the circuit clerk of the court.
Okay, so they just say, hey, I want my bond back, or like whatever's left of it.
If the case has resolved, that's when you can get the money back. You won't get it back if your case is still ongoing. But if your case is done and you return to all your court dates and you didn't pick up any new arrests, then there shouldn't be a reason for them to keep it. However, like I said, sometimes they use it to cover different fines and fees, or sometimes even people's attorneys take that money, you know, directly out of it. And so that's another way that people sometimes don't get the money back. And so, but yeah, I would say if those things don't apply, definitely go and try it.
Okay, thank you.
Absolutely.
Adeline, you had a question?
Yes. So I put it in the chat as well, but I was just wondering, is there a guideline? I am a legal advocate with Champaign County, and I am wondering if there is a place that we can refer people to if people are still being charged in the county for electronic monitoring, because I just can't, in good faith, like rely on Champaign County to update its system to have people not be charged, because it's hard getting everyone on the same page. And I don't doubt that people are still going to be charged even though they shouldn't be.
Oh, I'm sorry. I think that, okay, the Office of Pretrial Services would be the place to reach out to about people still being charged. So let me find the email for Cara Smith.
Okay.
I'll find the email for the Office of Statewide Pretrial Services, because that will be the place to reach out.
That'd be great. Thank you so much.
No problem.
I mean, we've never had an Office of Pretrial Services in Champaign County. So we will have a new one put in place by the statewide organization. Some counties do have offices of pretrial services, but Julia Reitz has consistently blocked implementing a pretrial services program in Champaign. Any other questions? So I'd like to ask one question. That would be, I know we've heard a lot of hysteria about the Pretrial Fairness Act, and I'm wondering, when people come to us and say, "What's going on with this? Aren't our streets going to be filled with criminals and crime and so forth?" What do you think our arguments should be in reply?
Yeah, so there's a few things, and I was kind of touching on this when I was talking about how we should respond to misinformation. One is, the problem is people are going to likely compare the implementation of this law to a standard of perfection, which doesn't exist and never existed. So I think reminding people of what our system was, reminding people that under our system, there was already the case that harm and violence continued under the current system because the system does not address root causes, and it puts people in cages and then spits them back out and somehow expects things to get better. And that's just not how things work. That's not how people work. The data actually shows that pretrial incarceration increases the likelihood that somebody will pick up a new case or have future contact with the legal system. You can have two people with the same charge, the same background. The person who is released will have better outcomes than the person who is put in jail before trial. It just makes sense. You put somebody in jail, their life starts to unravel, you spit them back out. Now they might be without a home. They might be without ability to get a job. They might be without connections to their loved ones. Do you think that that is going to support them avoiding or re-encountering the criminal legal system? And so just helping people to understand, we're in this prison nation where we've been indoctrinated to believe that these jails and prisons are keeping us safe. And it doesn't even make sense when you just break down how that is as a response to a solution. If anybody, I mean, I'm not going to get on a soapbox and go on with it, but yeah. And I would just say the data, okay? It's the data. Like, this is not just an ideological argument. This is not just a theoretical argument. Bond reform has been implemented in Cook County. It's been implemented in New Jersey, where their jail populations have reduced by like 30 to 50% without rises in crime. Even in New York, where there has been hysteria and media fanfare and people being turned against the reform, the data itself actually shows that it was successful and didn't cause a rise in crime. These are imagined phenomena. People are saying, based off of isolated incidents, that something is happening at a broad scale when it's not. And we cannot make policy based off of the 1% of incidents. It's not a logical way to do things. If any other policy had a 98 or 99% success rate, everybody would be singing its praises. But in the criminal legal system, when it comes to doing things differently, we want to hold things to a standard of perfection when the current system doesn't even provide anything close to perfection. So that's what I would say to the hysteria that we are bound to encounter.
Thank you, Briana. I see Carol has a question. Carol left.
Yeah, so it is a question. We start court watching next week, and I know the purpose of court watching is partly to see about how the system has changed, but also this early to see whether the judges, the state's attorneys, other people really understand the law and are actually applying it. And I wonder if so since we haven't started yet, I haven't been there to find out. So do we know anything from anywhere else about how well-versed people are and whether they're actually following the law?
Yeah, so far, there's been a good number of news articles that have come out covering implementation, so I can try to find some and drop them in the chat. But so far,
Would they be in Chicago? Because I haven't seen anything yet down here, but go ahead. Yes,
I
thank you.
haven't seen one covering Champaign County. I have seen some covering other counties. Overall, it seems to be going decently well. The first day we did have some discrepancies between counties that were treating the law as though it only applied to people arrested starting on the 18th versus, who were arrested before the 18th, but were appearing in court on the 18th. And so those discrepancies should pretty much fade out of the system by the end of the week, if not already. But so far, it seems like the law is mostly being followed. I'm not a public defender. I know our partners at the public defender's office might be getting more of the calls about specific issues with implementation, but on the large scale, we're hearing that it's going pretty smoothly. The sky is not our opponents.
Thank you,
with-
because we have Julia Reitz here, you know, so I'm not sure what that means for how much obstruction we're getting.
Yeah, so I mean, I should clarify that going smoothly, it doesn't necessarily mean that there's the outcome in every single case is what we want, right? It is the case that under the Pretrial Fairness Act, more serious charges are detainable. States attorneys have the right to determine whether they will request detention in any given case, and judges still have a right to determine whether they're going to grant it. And we know that there's a lot of bias that is baked into those systems and those processes. And so it is still the case that there are going to be more people incarcerated than we want to see, even under the Pretrial Fairness Act, but we do believe that it will be significantly less than before.
I just want to add that, I mean, Julia Reitz has her own history, but Julia Reitz publicly is claiming support for this and and also said that as from January 1st, her office was prepared to implement the Pretrial Fairness Act. So I think that's the public statement. So I mean, I think we should at least take that into consideration. So I don't know if we have no other questions or comments.
Can I say one thing?
Yeah, go ahead.
Because I noticed the news is on here, so I want to correct something that I said earlier about the idea that in some cases we've seen that there is a benefit in cases where there's a specific victim, for example, domestic violence or things of that nature when it comes to electronic monitoring, because I would be remiss not to also acknowledge, though, that electronic monitoring has also been a nuisance to victims and survivors as well, because the technology is incredibly faulty. So, you also have situations where victims and survivors are getting false alerts that they might be in danger, that someone might be out of their permissive zone or in the exclusion zone, when that may or may not be the case. The technology can produce upwards of 80% of false alerts. And so honestly, to the question of like who benefits from electronic monitoring, it really is just the companies in the system that overall benefits from incarceration. If we want to prioritize the safety of community members and even survivors, there are other ways to do that.
Okay. All right. Well, thank you very much, Briana. I really appreciate your input. Miana, I don't know if you have any comments or responses for the Bailout Coalition.
No, not for now. Thank you. I got the emails and the pages all written down. Thanks.
Okay, so I'd like to thank everybody for coming on. I'd like to encourage people to do what they can to ensure that the PFA Pretrial Fairness Act is implemented, and there's still opportunities, I'm sure, for people to join in court watch. I've done some court watching in Cook County, and it's very educational as well as helpful, because it's a way of making sure that the judges and the courts are following the letter of the law, and that people are getting the treatment that they're supposed to according to this. So I'll thank everyone. Yes, we will take this recording, and that will include the PowerPoints, and we'll share it out to everyone on the call and to the people who are on our listserv. So thank you very much, Briana, and thanks to everyone who's been on the call.
Yeah, thank you so much, Briana.
Thank you, everyone.
Thank you.
Of course.